On 8 July 2018, a loud bang disrupted the silence of the night. A drunken Olivia Chong lost control of a speeding car as it flung into a parking lot, killing 4. She was sentenced to 17 years imprisonment, a fine of 39,000 as she decided to file an appeal. Now the question arises, is her punishment too severe, or does she deserve such a consequence to her actions? Let's find out. The name of this case is Olivia Chong against Public Prosecutor. The citation of this case is 10 MLJ 19. This is an appeal case. Now I'll be moving on to the parties of this case. The appellant of this case is Olivia Chong while the respondent is Public Prosecutor. This court case took place at the High Court of Tawau and the judge was Alvin Abdul Wahab J. The date of judgment was held on the 25th of October 2019. Now, I will proceed to the background facts of this case. In this case, the accident happened within the shop lots at one arena. The accident was said to have happened at 1:20 in the morning, where 3 army personnel witnessed the car driven by the accused was driven at high speed as it knocked the dividers of the road and flung into the parking lots of one arena.
We welcome you back to fakenews.com for our daily newsroom.
Tragic news. The Tawau Police Department has reported a fatal car crash which happened around 1:20 a.m. last night.
Currently, we are informed that this accident resulted in the death of 3 men and a 16-year-old boy, while causing serious injury to 1 other man. The accident occurred in the district of Tawau, Sabah. Olivia Chong the driver who caused the accident, was driving her Toyota Vios above the speed limit around the area of shop houses known as Arena 1, near an army camp, which was where she loses control of her car and hit the road divider on one side and landed far to the parking spaces of one arena.
So last night I saw a car. The woman was driving the car very fast, and then I think she crashed over there, and then the car flung from there to there.
The accused was immediately taken to the Tawau hospital, accompanied by one of the army personnel. At the hospital, the accused blood was taken immediately. From the analysis, 171 milligrams of ethyl alcohol were found in Olivia's blood. Section 45, subsection 1, paragraph B, Road Transport Act states that the prescribed limit for alcohol is 80 milligrams of alcohol in 100 milliliters of blood.
The accused was charged with driving under the influence of alcohol more than the limit allowed by the Road Transport Act 1987 and causing the death of 4 people, which is an offence punishable under Section 44, subsection 1, paragraph B of the Road Transport Act, and the second charge was for driving under the influence of alcohol and causing the injury of 1 person, which is punishable under the same section. The learned Sessions Court judge sentenced the appellant to 10 years of imprisonment and a fine of 20,000 ringgit, and for the second charge, 7 years imprisonment and a fine of 19,000 ringgit. Sessions Court judge also ordered terms of imprisonment for both charges to run consecutively, as well as the disqualification of the accused driving license for the period of 10 years, which is 5 years for each charge.
So now I'll proceed with the appellant's ground. So the Session Court judge had erred in fact and law when he accepted the evidence of the medical officer who took the blood specimen from the appellant without requiring the certificate to be produced. The second ground is the appellant submitted that the learned Session Court judge had failed to conduct a maximum evaluation of all the evidence adduced during the trial. The third ground was that the appellant also submitted the learned Session Court judge did not accept the appellant's defense that she lost control of her car due to uneven or unlevel road condition, despite the fact that the court visited and saw by itself the scene of the accident. The appellant submitted that the whole jurisdiction under the Road Transport Act shall fall within the jurisdiction of the Magistrates Court pursuant to Section 116A Road Transport Act. It was also the appellant's submission that this is clearly a selective prosecution by the prosecutor to prefer both charges before the Session Court, as the magistrate's jurisdiction to pass sentence is only up to 5 years imprisonment.
On the first ground of appeal, the High Court judge dismissed this appeal on the grounds that the non-production of the certificate under Section 45F, subsection 3 RTA is not fatal to the prosecution's case, and it will only be fatal if the person who takes the blood specimen is not called as a witness. In this case, the testimony of prosecution witness 9 to account for the taking of the blood specimen can be tested and subject to further examination. The production of the certificate is merely to confirm that the blood specimen is indeed taken by the government medical officer. For the second grounds of appeal, it can be seen of the Sessions Court grounds of judgment, paragraph 52, that he stated having considered all these evidences, which suggests that the learned Sessions Court judge had considered all the evidence given during the prosecution stage as well as at the defense stage before he found that the appellant is guilty as per the two charges and subsequently convicted her. Hence, the High Court judge dismissed this appeal as well. On the third ground of appeal, the High Court judge dismissed this appeal as well on the grounds that he agreed with the Session Court's judge's findings that the car must be driven at a fast speed by the appellant, coupled with the fact that she was driving under the influence of alcohol, which would cause her to lose control of the car, hit the road dividers, and fling to the parking bay of one arena commercial area, resulting in casualties and the damage to the other cars. The Sessions Court judge was of the view that if it was true that the appellant was driving with a speed of only 90 km per hour as claimed, and even if the road was uneven as submitted by the appellant, it would not be reasonable to believe that the car would be easily going out of control beyond the opposite lane to the parking bay, which caused the tragic accident. On the fourth ground of appeal, it was submitted that the learned Sessions Court judge was motivated to punish the appellant for 17 years imprisonment, which is very severe and ought not to be consecutive. Further, it was also the appellant's submission that this is clearly a selective prosecution by the prosecutor to prefer both charges before the Sessions Court solely to increase the punishment on the appellant. The High Court judge allowed the appeal, saying that although the Sessions Court judge has the discretion to impose a sentence of between 3 to 10 years, to impose a maximum term of 10 years imprisonment is manifestly excessive. It is as if the learned Sessions Court judge had shut his ears to all the mitigating factors raised by the learned counsel in mitigation, including the fact that 1. This is the appellant's first offence, and 2. That its commission is one without intention to cause the loss of many lives and injury to a person. His Lordship also mentioned that the court must strike a balance between the interests of the public and the interests of the appellant in passing the sentence. This is why he allowed the appeal and reduced the imprisonment term for both charges to 8 years and 6 years respectively. However, he did not disturb the monetary sentence imposed by the learned Sessions Court judge for both charges, as they are within range in accordance with the law.
Very good morning to everyone. So today we'll be having a discussion regarding our case we have talked about yesterday, Olivia Chong or Yun. So we know that this was actually a drunk driving case, and we can see how dangerous drunk driving can actually get. So my first question to Kai is, what do you think regarding this analysis, the analysis of Olivia's case?
So, from my observation, I think Parliament has acted quite swiftly after the accident, as they have amended the Road Transportation Act in 2020, which is not long after the accident happened. So now Section 44, subsection 1, which is the section in question of the Road Traffic Act, was amended in 2020 so that drunk driving and causing death is now punishable by imprisonment of not less than 10 years and not more than 15 years. Before the amendment, the minimum was actually 3 years and the maximum was only 10 years. And as you can see, Olivia got the maximum before the amendment. So, and the fine imposed was also substantially increased from a minimum of 8,000 ringgit to the newest minimum of 30,000 ringgit. And the crime of drunk driving and causing an injury are now separated into two different sections of the Road Transportation Act. So now Section 44 subsection 1 is for causing the death after intoxication. Section 44 subsection 1A is now for causing injury. So before the amendment, these two used to be under one subsection. Now they are separated and they have different sentences for different crimes. So as you can see, Parliament has substantially increased the sentence for drunk driving, most likely for the reason of deterring the public from committing the same crime.
Thank you very much, Kai. So actually guys, we can see that there were amendments being made to the Road Transportation Act 1987. So I hope that with this amendment, we can actually see the cases of drunk driving can eventually decrease and we can actually make our country a better place, safer environment. So my question to Alisa, like how can you distinguish this case with other cases here?
Well, one of the cases that was distinguished in court was the case of Farid S. Shah Mansoor. And regarding the appellant's argument, it was found that the Sessions Court judge learned that they did not reach a legal conclusion, stating that the appellant was driving in a way that prevented her from having enough control over her car. And the argument is completely out of context because the case in question, which is the case of Farid Shah Mansoor, it pertains to an offence under Section 44 subsection 1A of the Road Transport Act, while the appellant in this appeal, which is Olivia, was charged under Section 44 subsection 1B of the Road Transport Act. And this provision does not require the prosecution to demonstrate that the appellant had been intoxicated by alcohol to the point where she was unable to operate her vehicle safely.
Nice. Thanks a lot, Melissa, for that wonderful critical analysis regarding the distinguish of cases. My next question to Lily, what is your opinion? What did you have to analyze regarding this case?
Well, I think in this case, we can see the impact it has to future cases because this case, for example, in the case of public prosecutor against Mohan Rao, anak lelaki Natchana, 2022 case, Olivia Chong her case was used to serve as a guide for the elements that must be established by the prosecution to secure a conviction under Section 44, subsection 1, paragraph B of the Road Transport Act, where the court ruled that according to Olivia's case, there are three elements that have to be proven. One, that the appellant was driving the motor vehicle on a road or public place and it was said that the motor vehicle was the one that caused the accident. Second one is that the alcohol level in the appellant's body exceeded the prescribed limit, 80 milligrams of alcohol in 100 milliliters of blood. And lastly is that the reckless driving of the appellant had caused the death of 4 persons and injury to another person, as in the case of Olivia, where in this case, it was established accordingly by the elements. There was 102 milligrams of alcohol per 100 milliliters of blood in the accused's body. There was a strong speeding sound that indicated that the defendant in this case was driving very fast, and also there was blood splashed from the victim on the body of the car driven by the accused person, which suggested that the car itself actually hit the victim. So from this case, they were able to establish these elements and subsequently charge the defendant with their own sentence of prison of 4 years, fine of 15,000 and 5 years of suspension on their license, if I'm not mistaken. I think there was also another case in 2023 recently that was also using Olivia Choi's.
Exactly. So regarding to what Lily has actually said, so there was actually a recent case which happened in 2023. So this was in the case of Pendakwa Raya against Darwin Raj. One of the requirement was actually is highlighted by the learned session court judge was that the appellant was the one driving the said motor vehicle on a road or public place, and it was the said motor vehicle which caused the whole accident. So if you see, take a look back in Olivia's case, she was the one who was driving her own vehicle. She was the accused who was driving the own vehicle, and this goes aligned with the Darwin Raj case as well. And if you can see that the second element, as you mentioned just now, the alcohol level in the appellant's body exceeded the prescribed limit. So there's supposed to be 80 milligrams in 100 milliliters of blood, but unfortunately it exceeded, and because of the reckless driving of the appellant had caused the death of 4 persons and injury to another person. So this is highly linked with the Darwin Raj case as well. So now my final question to Josh, what do you think regarding this case? What is your analysis?
I think this is a very hard decision for the High Court to make, because in such kind of issue it's very controversial. On one hand, you have Olivia who's drinking and driving, and that is very irresponsible on her part, and furthermore it caused the death of 4 persons. 1 person is a minor somehow. But on the other hand, we also have to consider the circumstances which was indeed considered by the court in making the judgment. How she is separated from her husband, she has to raise a son with some sort of illness, and then she has to take care of
Second father.
her second father, and then her family members. Okay, so there's a lot of burden on Olivia also. On one hand, you have the law. On the other hand, you have to realize that Olivia is human also. The public reaction is also going to be quite extreme, because drunk driving is a very sensitive issue in Malaysia, because it happens sadly quite often. So regarding the change in legislation, as what Kai has mentioned, I think it's actually very great. I applaud the decision by the parliament to amend it, because now people who are found guilty of drunk driving, they are actually able to receive the proper sentence that they need to serve in order for the society to know the dangers and the risks of drunk driving and how they should not do this. If they do, they need to face the responsibilities and the consequences of their actions.
Yeah, actually following up with what Josh said, I wanted to ask you guys, what were your opinions about the changes of legislation? Don't you think it's a bit reactionary, because the timeline seems a bit suspicious, because it was just shortly after the appeal was heard? So there are some that argue that a harsher sentence would not really be effective in deterring the public from committing the crime. What are your opinions? Do you think the changes are justified?
Thanks, Kai, for the question. So actually I agree with what Josh has said earlier. By putting harsher years imprisonment and all of this can actually educate the people, because when you hear case of drunk driving and then 10 years maximum imprisonment, I think that it actually gives an awareness to the public. Like, they would know that if you do such an act, such an irresponsible act, people actually get scared and would not want to take the risk of drunk driving next time. In a way, you can actually see that the cases of drunk driving will eventually decrease.
But do you guys think the increase was a bit too harsh though? Because the minimum sentence was increased from 3 years to 10 years, which is more than 3 times. The minimum fine was increased from 8,000 ringgit to 30,000 ringgit, so which was also more than 3 times. So do you think it's too much, or do you think it's justifiable?
In my opinion, it is quite justifiable, because I think that drunk driving is a crime that you can't even put the blame on anyone else but yourself. Once the public knows what the consequences are of drunk driving, you get caught, you somehow hit someone and that person somehow dies, your actions should be, the punishments to your actions should be equal.
I think that the harsher sentence, like you said, it may not be that effective in deterring the public, but I think at the end of the day, no matter how harsh the sentence is, if you're going to drive drunk, that is your decision and you have to take responsibility on it. Raising the sentence of from 3 years, minimum 3 years, minimum of 10 years, right? Amendment is minimum of 10 years, right?
Yes.
The new one, raising that, it just shows the public's like hate towards this crime. Like, we really don't want anyone to do it, which is why we raised it.
And then furthermore, to add on, I don't think like this additional punishment doesn't just serve to deter the public from doing such an action, but it also serves as more of a confrontation to the families of the victims of drunk driving. This serves as, how to say, a bandage to the wounds that they suffered. Something is done to it to prevent more people from having to facing the same kind of grief.
But are you guys worried that this kind of action by Parliament will be a slippery slope? Every single time a crime has become viral, Parliament will just increase the sentence to deter the people.
I think that if it's gonna be a slippery slope, that's not exactly the case because of our system. I think when you have check and balance, when you have a law passed by Parliament, even so, the courts can still voice out their own, like, if it's too much, I think the courts will say something, in which case the parliament would have to like look back at it and understand. And I think when you pass a law in parliament, it is still the decision of many people. Those people in parliament have the responsibility to look at, isn't it going to get to a certain point where it's kind of absurd, but it still has to reflect the public's deterrence on the case. So if, say, it still keeps going and no one seems to be showing any signs of stopping, maybe that's the measures we have to take to, reduce.
With that final answer given by Lily, I think we can already conclude our today's discussion. I would first of all thank every panelist here who have actually given their opinion and thrown questions at us. We have discussed a very important case, and see you guys in the next episode. Bye.
Bye.